I'm Maurice Crespi, Managing Partner of Schindler's Attorneys, co-founder of COBRA. We joined today by Dean Wright, my partner. It says Derek of IQ. I'm not sure why, but it's actually Paul Michael of, another partner of mine from Schindler's. We have Peter Gordon from Engaged Business Turnaround, Artisha from the IQ Business Group, and Francois from the IQ Business Group. So welcome to our panelists. Thank you for joining today. We have an additional panelist, Ian Fleming from Engaged. He's a business rescue practitioner, as is Peter Gordon. The idea today is to go through questions that you may have. The format of today is a Q&A type session. I'll be answering, asking questions of the panelists and answering some of them myself. But the idea is that the participants please ask questions that are specific to your industry or to your business, particularly because if you think about it, we could just pre-record one of these, go through business rescue and play it every day. Whereas the idea is to have one of these webinars every day so we can reach out to you guys and deal with your specific problems. If I ever, the questions only arise after this webinar, please feel free to arrange a private Zoom session with the COBRA team. It's part of the Pro Bono initiative, and there's absolutely no reason why you shouldn't do it. We can also do it with your staff. We can do it with the directors and the like. So if you do have questions after this, please just email us and we'll set up that session. I'm going to kick off just with a general discussion on business rescue, just a high-level review of what business rescue is about. But before I get there, it is important for us to emphasize as COBRA that COBRA is not about business rescue. Whilst we have business rescue practitioners, they are there as a last resort. The COBRA ecosystem is designed to avoid a business rescue, to be able to comply with the Companies Act by virtue of certain provisions we will take you through. For instance, you have to vote to put a company into business rescue, and you have to notify the employees and creditors if you don't. Well, now you can comply with your legal obligations by saying, we're not going into business rescue because we're going into COBRA. And COBRA is about mediating with your creditors, getting your creditors into the ecosystem, creating a marketplace within the ecosystem so you guys can feed off each other's products and services, but importantly, to negotiate up the ladder all the way to the bank. So from the spaza shop all the way up the ladder to the bank, all those creditors, the idea is to have them all agree to payment terms that work for everybody. And that's why we have a team of mediators to fulfill that function. So let's kick off. Peter, take us through BR.
Maurice, thank you. Morning, everybody. Business rescue, it's created in Chapter 6 of the Companies Act. Companies Act of 2008, promulgated in 2011. Essentially, the most important thing of business rescue, it provides an absolute moratorium against any legal action against the company. That's not only recovery of debts from the company, but any legal action whatsoever cannot be taken against the company unless, of course, somebody's applying to have the business rescue overturned, which is possible. The principle of rescue is directors take a resolution. They appoint one of their members or a group of their members to sign an affidavit. The important thing in the affidavit is that the directors have to have stated that the company is financially distressed. What does that mean? In terms of Chapter 6, it means that the company believes that it will not be able to settle its liabilities, its creditors in other words, within the next 6 months as the first one, or it believes within the next 6 months the liabilities of the company will exceed its assets fairly valued. So if either of those exist, in the current crisis that we're facing, it's normally the former, is that the directors then have the obligation to consider business rescue. At that board meeting, it requires a 50% plus one majority. And if the directors conclude that rescue is the answer, as I said, they do the resolution, file it at Companies House together with the affidavit. The other important thing in business rescue is the directors have to be of the view that the company can be rescued. That is, over a period of time, the company can return to a solvent position or a financially stable position and settle up their liabilities. If that exists, the resolution together with a couple of forms are filed at Companies House. It's all then time driven. The directors have to appoint a practitioner or practitioners. Ian and I take a lot of joint appointments ourselves. Once the practitioner's in situ, he or she has a supervisory control over the board. The practitioner is then obligated to file a business rescue plan, which needs to be voted on by what is called the affected persons, broadly the creditors, but includes shareholders' loans, director loans, staff if they still owed money, which they always are, unpaid bonuses and leave pay, etc. Staff are always creditors in a company. Vote on the plan. These are two votes. The staff have a separate vote and the creditors and shareholders a different one. The process that you follow is to put a plan together to say a bit what has happened in the company, why it's in its current situation, and what the plan is to get it out of its current malaise. Now, that plan can be as broad as any business plan, let alone a business rescue plan. The practitioner can sell off assets. He can use the assets to secure new funding for the business. He can reduce the staff numbers, but staff are all still protected by the Labour Act. The Business Rescue section of the Companies Act specifically includes the fact that you cannot affect employment contracts whilst in rescue. So any reduction in staff through the normal Labour 189 process still has to follow that route. There's no short circuit to suddenly get rid of the staff rapidly. Clearly, doing a downsizing of your workforce involves redundancy payments, etc. So one's got to weigh up whether that additional cost can be afforded in business rescue. Once the rescue is substantially complete, and the important word there is substantially, so the practitioner has to assess and would normally, not always, but a good practitioner will include in his plan what he defines as substantially complete. And if you've done virtually everything and there might be some final payments due to creditors, the practitioner would be well advised to put the money into trust at the lawyer's accounts and make sure that those creditors are paid and take the business out of rescue. Maurice, I think that's a general overview. If there's any other thing that I've missed, please shout.
No, that's great. You've covered everything. What we'll do now is we'll go into specifics, what we've termed the take-homes. So I think to begin with, we have this moratorium. The moratorium is obviously very, very important because if a creditor comes along and starts being pushy, starts threatening to liquidate, what one does is one can resolve by way of a general resolution to put the company into business rescue. But it's only really required if they become pushy to get the moratorium. But one of the take-homes, and I touched on it, I think Peter touched on it, is the contracts that you're bound by. When you go into business rescue, it's very important for the business rescue practitioner to send a notice to the counterparties to those contracts, suspending the contract. So let's say there's a lease agreement. The notice must go out by the business rescue practitioner to suspend the lease. If one does not do that, it's still competent for a creditor to send a demand, or a landlord, let's say, to send a demand, cancel the lease, and then evict if that notice hasn't gone out. So often there's a race between the business rescue practitioner to get the notice out and a breach notice in terms of the lease. Peter, you again, I've mentioned contracts. You touched on employment. Just on employment and the contracts. In fact, I'm going to jump in here and I'm going to actually deal with Section 189 in the context. So first of all, the contracts of employment are excluded when it comes to the suspension that the business rescue practitioner can attend to of all other contracts. So we mentioned that it's necessary to still, Peter mentioned that it's still necessary to consult with those employees, and that it's Section 189 of the Labour Relations Act still comes into effect, which means that you need to consult, in terms of Section 189, on the reasons for the proposed dismissals, ways to avoid the proposed dismissals, factors considered to mitigate the adverse effects of the proposed dismissals, the likely severance pay, and this has to be set out in a written notice to the employees. If the employees do not agree to, let's say, a variation of an employment term as an alternative, so let's say a reduction in salary as an alternative to retrenchment, then you still have to pay them the retrenchment, the severance pay, which is 1 week per completed year, or in terms of the company policy, if it has a policy regulating severance pay. So there is that dilemma, because you need to change the employment terms, but what if they don't agree? Then you're stuck in a bit of a bind. So what we've encountered, and there have been questions now around employees, and that is shareholders have been funding, have been paying money on loan account to companies to fund shortfalls in salaries. And I'd ask Peter to pick up on that with reference to post-commencement finance, whether that's a good idea, and if one is going to do it, how one ought to do it. Peter?
Maurice, look, the critical thing here is if and this normally applies to the SMME market, if a shareholder, owner, or director decides to fund the business because they really have belief that this business can be rescued or can trade out of its current situation, not rescued, and prior to going into rescue, any investment made in the company, if the company then goes either into rescue or liquidation, unless that shareholder, director, etc., has taken security over the loan, they then lumped in with the what we call the concurrent, i.e. the unsecured creditors, and they stand almost at the back of the queue in any payout, slightly ahead of the shareholders themselves. So what the idea would be is, if you are firmly of the view that this company can be rescued, then for goodness sake, put it into rescue, because the important point is any funding that is received post the rescue date is then preferred over all other liabilities. So in the profession of rescue, we talk about drawing a line in the sand. Anything that's behind that line is frozen, as Maurice said. Contracts, security is frozen. You're not affecting the security. So if the bank's got a piece of security over their loan or their overdraft, it's not affected from the point of view, it still stands, but they can't exercise it. So it's frozen from that point of view. But anything coming in post-rescue, if the company then either goes into liquidation, unfortunately, but this does happen, if it then goes into liquidation, that amount, if it's secured, is considered super preference, so that amount will be paid out. The important point to note there is, if it's security that is already or over which there's already a charge, classically a piece of property where you've got a first and second mortgage bond. The first bondholder obviously still has first bite at the cherry, whatever realized from that asset, and the second mortgage holder will have the rump of what remains. So, but the important thing is it gives the shareholder preference in his payout. The practitioner is then obligated to pay all the post-commencement funders. Not always possible when things go horribly wrong, but that is essentially the rule. And if it weren't that way, believe me, nobody would be even minded, especially the banks, to continue funding businesses that are in rescue. You have to give the people who are prepared to take that additional risk the preference of being put at the front of the queue.
Thanks, Peter. Whilst we on labour, can we turn to Ian? Ian, you've had various discussions in the past in relation to variable costs, and that applies to leases. As a business rescue practitioner, you going in, leases and employment contracts. Practically, can you take us through what you do once the company's gone into business rescue, apropos the employees?
Yes, certainly. So, Maurice, there's been one of the things we've realized, and I think a lot of people across the world are starting to realize, is that the need to move into a variable cost model as much as possible. In other words, where your costs of running the business are very much linked to your turnover. In other words, your costs are linked to the money that you're bringing in. And we've, as you touched on earlier, in dealing with employees, moving into lower salaries during the crisis. That's very much what we're driving, and employees have been very much focused, or they've been very cooperative and very much embracing the idea of reducing their salaries sometimes to a very large extent, in order for the business to be able to afford them, to keep them on. And then at the end of the crisis, hopefully they'll still have a job. And then as the companies start to rebuild, then their salaries can be once again be increased incrementally. Very similarly, we talk about putting landlords onto variable cost structures. In other words, turnover-based rental or turnover-linked rental. And some of the discussions we've been having with landlords are really kind of pushing the limits as far as turnover-linked rental goes. So the moment the COVID crisis or the moment the lockdown finishes, we'll have some of our clients coming out and being able to pay a significantly reduced rental because of the fact that their turnover is significantly reduced over time, and provided the economy recovers and carries on growing. And obviously in the long term, the landlord will see the benefit of that. So there's a quid pro quo, because his rental will be higher as a result of the turnover of the company being high. But yeah, as far as employees goes, it's obviously from a practical perspective, it's a very sensitive thing that needs to be handled very carefully. Within 10 days of being appointed, the business rescue practitioner holds what we call a Section 147 and a Section 148 meeting. That's where he meets with the creditors and the employees respectively. He tells them or informs them of his whether or not he believes there's a reasonable prospect of saving the company. Obviously, most of the time he will tell them that there is a reasonable prospect of saving the company, hence the reason it's still in business rescue. If at any stage he believes there is no longer a reasonable prospect, then it's his obligation to put it into liquidation. But yes, and at that stage of the game, the practitioner normally, he's not duty bound, but he normally informs the employees as to whether there will be retrenchments and so on, and layoffs going forward as part of the business rescue plan. And then he is able to effect those retrenchments in advance of publishing the business rescue plan, or he can, in the business rescue plan, set up the retrenchment plan. But it does actually very often happen before the business rescue plan is in fact published. Anything from your side, Peter, on that subject? Marisa, are you there? I think we've lost you.
Yeah, Maurice is off for some stage. But yeah, and look, I think the important thing here is that it is quite critical that the business rescue practitioner, because remember what we're trying to do is rescue the business. The important word here is rescue. And rescue means giving it a lifeline and allowing it to continue to trade, possibly in a cut down version, i.e. smaller business, but one that can trade profitably going into the future. The practitioner cannot hand back a company that is still distressed. There would be no point in doing that, taking it out of rescue. The next day you get everybody queuing at the courts to lodge liquidation applications. That's a complete failure. So, you know, it is important to work with the directors and the management of the company. As Ian rightly says, unfortunately, the absolute staff numbers might be reduced. But by working with, you know, Ian and I say this so many times, for goodness sake, neither of us have the knowledge about the company that the founder and or the current CEO and executive management have of the business. Why would we go and try and usurp that authority by pretending we know something about whatever the industry the company's in? No, absolutely not. We work together, obviously subject to fraud. I have had a few where there's been fraud by the board. And in those scenarios, you know, one in an extreme case has to sideline the board. The reduction in staff, as Ian covered, can be done in rescue. The removal of a director from the board. Remember, director is an employee, but also has fiduciary duties as a member of the board. You can have a director removed, but you've got to go to court to do that. Having a director move from his, if he's an executive director, from his employment contract would fall under the same 189 rules in the labor law. But it's important to remind everybody that directors retain their fiduciary, broadly maintain their fiduciary duties towards the company. The practitioner can ask for assistance or not, as the case may be, from the directors. But then also importantly, the practitioner himself or herself carries full fiduciary responsibilities vis-a-vis the company. So it's not a position to be taken lightly by practitioners. One's got to be very cautious that, you know, you're taking something that you believe, and you have to state to, as Ian said, to the staff and the creditors, that the practitioner does agree with the director's resolution, i.e. that the company can be rescued. All it needs is a bit of time to do so. Sorry, Maurice, we lost you there for a minute, so I just talked about directors and their responsibilities.
Yeah, you mentioned fraud, so I'll turn to Ian, just dealing with the reporting of the obligations of a business rescue practitioner. Once appointed, and very important for the audience, this only kicks in once the business rescue practitioner is appointed. Many questions have been asked in relation to what happens if the books aren't as accurate as they should be, and the income has been under-declared, or expenses over-declared, or there's been a juking of the books. What then, Ian?
So, Maurice, as officers of the court, we are, as business rescue practitioners, required to report to the relevant authorities any instances that we come across of irregularities perpetuated or committed by the directors leading up to the business time that the company went into business rescue. Now, in reality, SARS knows, and we all know, that a lot of companies cheat their taxes. We are not there we're not auditors. We're not there to look for errors like that. However, if we come across them, or if the company tells us that they have been cheating on their taxes, then it obviously is our responsibility to go to the relevant authorities. In this case, the relevant authorities would be SARS. So what we've done in situations like this in the past is that we would work out the extent of the under-declaration. We would then approach SARS on a voluntary basis. Now, SARS is open to this. SARS, and I say this all the time, SARS is not there to shut businesses down. You will never see a liquidation application coming from SARS, and I don't think SARS has put a director in jail in the last 10 years. I stand to be corrected, but they are not there to put people in jail. They're not there to shut companies down. Okay. So SARS looks very favorably upon us approaching them with voluntary disclosures. Okay. So the nice thing about business rescue is that creditors all inevitably take a compromise under business rescue, or a haircut. In other words, the amount owing by the company to those creditors gets reduced. So this enables us to go to SARS and say, Company A, we said to SARS, Company A underdeclared their taxes by 500,000 Rand, a million Rand, whatever the case may be. But we're in business rescue, and we're SARS to enforce the collection of all this money that would sink the company. What we then request SARS to do is to reduce, we negotiate with them, as we negotiate with all the creditors, to reduce their the amount owing to them down to a level that is affordable to the company. Often the amount that we manage to settle on is less than they originally had in their books as owing to SARS. So there we have a solution. Us as the company, as a result of us getting involved and going into business rescue, is not in a worse off position. We are not more indebted to SARS. We've come clean with SARS. Nobody's in jail, and the company continues trading. That's typically our modus operandi, and hopefully that answers a lot of the questions that have been put forward to you, Maurice, and hopefully it sets a lot of people's minds at rest as to how we will deal with SARS going forward and how we've dealt with them in the past.
In the context of reporting obligations and alternatives to business rescue, obviously the one is that the turnaround experts negotiate with the creditors outside of business rescue, but there's also Section 155 of the Companies Act. Tell us what that's about.
Yes, Section 155 is often a very nice way of doing a compromise without having the label of business rescue. And Section 155 can be something that we'll probably be using quite extensively in COBRA, because it doesn't involve the label of business rescue, or what some people perceive as the tarnish of business rescue. It's simply a case whereby the rescue practitioner, or let's call it in this case the turnaround practitioner, negotiates with each class of creditors in order to achieve a compromise, or in layman's terms, a haircut to the amount that the company owes that creditor. It does not take place under the protection of a business rescue regime. So the potential downside to it is, while the practitioner is negotiating the arrangement with creditors, a hostile creditor can potentially apply for liquidation or can get a judgment against the company and in order to attach assets. Those in business rescue, the company would be protected against those things happening. So eventually, once the practitioner or the turnaround practitioner has put together his plan, he'll get all the creditors together, and each class of creditors, in other words, secured creditors, and then preferent creditors being stars and employees separately, and then concurrent creditors would each vote whether they approve the compromise or whether they reject the compromise. It's a requirement of the Act that a 75% vote in each class be achieved in order for the vote to be passed. And once it is passed, once all classes of creditors are comfortable with the compromise, then the practitioner takes it to court and he gets the compromise made in order of court. As of that moment, the creditors' balances are all reduced, they've all taken a haircut, and the company can trade forward from a solvent position.
Great, thanks, Ian. I'm going to jump around a bit. We've dealt with staff, but what we've overlooked are the options available to distressed companies in relation to the staff and the various funds. Dean, can you take us through those, please?
Yeah, sure. Thanks, Bruce. And you're right. There are so many relief packages that have been put out there. And I think, yeah, you touched on two of the most important ones, is the staff aspect, and then there's obviously the retail one. In terms of the staff, the one that we get a lot of questions about, and just for the audience, is that if you go to our COBRA website, which is cobra.org.za, if you scroll to the bottom of that website, you'll see we have a plethora of all the relief measures and funds that are available in various sectors. But for the purposes of today, I think the TERS one is one I'll be chatting about. This is the temporary employee relief benefits. And what this is that the first point is you have to be registered and for UIF and have been paying UIF prior to COVID. Okay. And one of the questions we chatted about quite a bit is whether, if you were behind on your UIF payments, you could regularize this. And the question hasn't been definitively answered, and I've discussed it at length with one of my partners that does this, heads up our labor department. And the point is, the only requirement per what we've read is that you had to have been registered for UIF pre-COBRA, or COVID, sorry. And the point of the fund is to assist employees, so it would not make sense that these employees would then be not entitled to the benefit because payments went up to date. So what we've just looked at and what he advised is that a lot of times prior, when UIF payments have not been up to date, they've entered into acknowledgements of debt and those type of measures to bring everything up to date. So that's where we are. We don't have a definitive yet. We're actually waiting to get hold of the UIF. But in a nutshell, you have to be registered for UIF to make use of TERS. And there's various percentages that you would be able to claim for your employees. One of often the question is, does it have to be all my employees or some of my employees? And the simple answer is it can be a portion of your employees, particularly ones that you either or aren't able to work fully at home or are able only to work partially at home. And you could supplement their income by making application to TERS. And just in terms of the initial key documents, and this is straight off our COBRA website, you'd need a letter of authority. You would then have to enter into an MOA, which is a memorandum of agreement with the UIF. You need a prescribed template that requires critical information from the employer. And this is where we get back to is evidence and payroll as proof of the last 3 months of employee salaries, and then confirmation of bank details. So there's various percentages on how much you can claim in terms of TERS. And the maximum we've seen is they've pegged the maximum salary amount to 17,000 Rand, and they've worked out a percentage of that, which is about 38%. So it brings us to about 6,700 Rand as an amount that you could supplement your salary or claim. It all depends on how much you earn on a monthly basis.
Brilliant. Thanks for that, Dean. Before I go to Ian on the business rescue plan, we dealt with the moratorium, but a question often arises, Peter, as to the status of surety ships. Can you take us through that?
Bruce, yes, important point. It's a question we ask any company that's deciding to go into rescue, and that is, who's signed personal surety ships on behalf of the company? Very often in a small to medium company, this is directors, shareholders signing personal surety ships in favor of the bank or any alternative funder. An important thing there is to understand the wording of the surety ship. But there was a recent case, and I'll let Ian talk to it in a second, which essentially most surety ships nowadays will identify business rescue itself as being a default. And in the event of a default, the lender or the creditor can go after the individual. He doesn't have to go via the company, if that makes sense. So the fact that this person or the lender is going to get paid out in terms of a business rescue plan, that's in the future, you're never 100% certain of that. There's nothing to stop that lender going against the individual directly. So surety ships are a very important thing. There's also been a question, well, should I settle up my obligation? So I've given my personal residence as security over my bank overdraft to the company. Should I sell the residence or take a second mortgage over the residence to pay up the company? And the same would then apply to what I discussed earlier. Please do that in rescue, because if you're doing it outside of rescue, anything you settle up in the company, unless you've taken security against it, but even if you have, is then frozen in the rescue. So far better to put it into rescue, realize your personal asset if you've decided that that's the most sensible thing to do, and put that into the company by way of PCF and use that to settle up the secured creditor. Nothing to stop you doing that, a deal almost outside of the company to settle up the bank so that they're removed as a creditor. It is something that you would want to discuss quite closely with the practitioner, because it may not make economic sense to do that, but and notwithstanding that the practitioner is there to rescue the company on behalf of the affected people or the creditors. But, you know, as I said earlier, one does work with management and shareholders and directors to try and get the best result possible. And if it doesn't make economic sense for everybody, for somebody to settle up a personal surety ship, but bearing in mind that the bank can still go after that individual.
Thanks. Jump in there. Sorry,
I thought at one point, just on, did you deal with the aspect of rather settling the surety via PCF? I may have missed that.
Yes. Yeah,
okay,
no, I did.
Okay, fantastic. Over to you, Ian, on the business rescue plan.
Just just on the sureties, the legal precedent now on sureties has been set by the Newport Finance case, which was or judgment from 2016 or 2017, where the judge found that the surety in that case stated explicitly that the compromise in the business rescue plan only releases the principal debtor, so and doesn't extinguish the debt. So the surety contract specifically stated that if the company goes into business rescue, then it does not extinguish the existence of the debt. And what the judge pointed out in that situation is that business rescue could never have been intended to protect sureties. Business rescue was only intended by the Companies Act to revive ailing and distressed companies. If the Companies Act had intended to protect sureties, which could surely never have been the case, then it would have explicitly stated that in the Act. So that's obviously not good news for anybody who has signed personal sureties with the banks and so on. All the banks nowadays have similar surety agreements to the one that Newport Finance had in place in that case.
I think that's a very important point. The law without a provision along those lines is that if the principal debtor compromises, well then that compromise will also benefit the surety. But as you pointed out, what's happening now is that's dealt with contractually in the suretyship agreement, saying that any compromise will still give rise to, well, any shortfall can be recovered. Yeah, so just to take us through the business rescue plan.
Yes, certainly. Okay, so the business rescue plan is really contains what you would find in a business plan that you would present to a bank. At the end of the day, it's a plan. It is a business plan that you're presenting to creditors, and it basically sets out what the turnaround plan is from an operational perspective, from an equity restructuring perspective, if applicable, from a debt restructuring perspective, etc. It's really a transparent, full analysis of the business. It's got in it is what assets are, a breakdown of the assets, a breakdown of the market value of assets, breakdown of assets that are available for sale that are not being utilized in the running of the business, a breakdown of creditors by creditor class, whether they're independent creditors, whether they are not independent creditors. Very importantly, a business rescue plan contains a liquidation calculation. In other words, a depiction of what creditors would achieve or what the dividend would be to creditors in a liquidation scenario. And one of the main purposes of business rescue is to give creditors a better return than they would get in a liquidation. Otherwise, you might as well just liquidate the company. So, yes, very important to the liquidation calculation, and then the business rescue calculation. In other words, showing creditors what they would get as a dividend were the business rescue plan to be implemented successfully. And then, as any good business plan would have, the Companies Act requires the business rescue plan to have 3-year financial forecasts. In other words, income statement, balance sheet, and cash flow forecast for the company for the next 3 years, showing everything that an income statement and balance sheet and cash flow statement shows, and ultimately showing how the creditors will be settled out of those future profits, if that is the case.
Great. So when it comes to the voting of the plan, Peter, I'm gonna give you an example, and I'll ask you to deal with it. So hypothetically, let's say that there are only 2 creditors of the company. One is a shareholder on a shareholder loan account, and another creditor is just in relation to an ordinary trade account. And the shareholder loan is R1 million, and the trade creditor is 50,000 rands. And now it comes to voting on the plan.
Maurice, importantly, to get a business rescue plan approved and adopted, the practitioner has to get a 75% positive vote, and that is 75% of those creditors voting by value, in person or by proxy. So if the creditor is not present to vote, he can't claim after the event that he didn't support the plan. If 75% of those in attendance, as I say, can be by proxy, vote positively for the plan, then the plan is adopted. However, that 75% is also premised on the fact that 50% of those voting have got to have been independent. Now, if you've got a shareholder loan, it's a class that's non-independent. It's a connected party loan. So your 10,000 or whatever the figure is that you use, Maurice, there, 10,000 rand creditor would have a strong say in the rescue, because 50% of your vote has got to be his vote. In this case, it means your shareholder would have to reduce his vote, and we often do this. You reduce the shareholder's votes in order to get the plan through, obviously in consultation with the shareholder. The shareholder's got to agree that the plan is acceptable, because if the shareholder votes his R1 million and the creditor votes his 10,000 rand, the plan doesn't pass muster, because it doesn't meet the 50% requirement. So it is important to decide how much value of his claim the shareholder should vote, so that he at least is supportive of the plan, and that's indicated in the vote, and thereby getting your 50% for the independent creditor. Connected parties, intercompany loans, shareholder loans, directors loans, staff loans to the company if they're in senior positions, anything like that would be considered a connected party loan, and therefore it doesn't meet the independency rules.
But now you have a 50,000 rand creditor calling the shots. You know, effectively then the creditor surely then controls the business rescue plan and needs to come up with the business rescue plan and dictates what the business rescue plan is.
Maurice, yes, and I mean, one of the important things with the business rescue plans is, and we often say this, it's the beginning of the negotiation, because it's a bit, and it does happen, unfortunately. Studdiford's is a good example where the plan couldn't get voted through on a couple of attempts, and then eventually filed for liquidation. You have a situation where you're trying to get everybody in agreement, not always possible, especially when you've got an acrimonious creditor or shareholder. So what you're trying to do is get your plan through. If you fail to do that, and you've got a 50,000 rand creditor who's calling the shots, obviously anybody who's an affected party can go to court to have a vote overturned as inappropriate. And, you know, I mean, I can't imagine a case, but if the plan is totally detrimental to the shareholder and totally positive to the creditor, would be something the creditor would want, obviously, but one's trying to aim for a win-win situation. If you aim for a win-lose situation, then you're likely to land up in court with somebody applying to have the plan overturned.
Any other affected person is obviously in a position to buy that person's claim as well in order to secure their vote. So
very important. If it's in those circumstances, it would be in the shareholder's interest to actually go and pay the 50,000 rands and then control the plan. But Ian, what happens if the shareholder controls the plan, comes up with a plan that just simply doesn't work? So you try and execute on the plan, and 6 months later you find out, you determine that the plan is actually a bad plan.
Well, then the business rescue practitioner has to evaluate, first of all, he has to evaluate whether he still believes the company will get a better return than in liquidation. If not, then he's obligated to liquidate. If he still believes that the company will get a better return than in liquidation, then normally under pressure from one or two of the creditors, he will redo the plan or revise the plan, and he will then take it to the creditors again, and he'll reconstitute a Section 152 meeting, present the plan to the creditors, and once again allow them to vote whether to adopt, accept, or reject the plan. Obviously, at this stage of the game, some of the creditors may already have been paid off, and the creditors, so the makeup of the creditors may have changed. Additionally, and this lines up with a question that's just come through from Erwin, creditors may have put in post-commencement finance, so that the structure of the creditors would, under normal circumstances, have changed quite substantially if that happens. What we do in this case, and the Act is actually silent on it, but the generally accepted practice is for us to constitute the creditors or to allow the creditors to vote as they stand at that stage of the game. And that is normally, if you think about it, the fairest way of dealing with it, because at that stage of the game, that's what each creditor or each creditor's risk is, and therefore they should have a proportionate vote. So whether at that stage of the game, whether it's post-commencement finance creditors who are new to the party, or whether it's existing creditors that have been repaid to an extent, what they are at the reconstituted vote is the vote that they hold. And then they vote on it, and if it's approved, then we carry on implementing the plan according to the reconstituted plan. If they reject it, then it's the normal process of dealing with a rejection of a vote at a Section 152 meeting.
Also, good, John. Sorry, Peter.
I was just going to say one of the intriguing things, because directly to Owen's question, anybody putting money into the company post-rescue then has a vote on the plan, which is what Ian's saying. We've certainly taken advice on that on a number of occasions. The intriguing thing there is, of course, the rescue practitioner suddenly becomes a creditor, because inevitably, not all these fees have been paid. He would be considered a connected party, not independent, but he ends up voting on his own plan. It's just an intriguing anomaly in the voting process, but the practitioner could well have a significant vote if he hasn't been paid for some time. in relation to the total quantum of creditors. Sorry, Marisa, I interrupted you.
No problem. Whilst we're on fees, can you take us through, Ian, the fee structure of a business rescue practitioner, how disbursements are dealt with, the various skills of the business rescue practitioners? Yeah, thanks.
Sure. So the fees are legislated by Chapter 6. Typically range from 1,250 Rand an hour, including VAT for a small company, to 2,500 Rand an hour for a large company. Before I say anything further, the way that we've worked and engaged since we were established 4.5 years ago, and the way that we work in COBRA, is based entirely on affordability to clients. In other words, what can the client afford to pay us is the number one criteria when determining fees. We don't want the company to be in a worse position as a result of our involvement than they were without our involvement. And that ties in obviously with the pro bono aspect that Maurice talks about all the time. We won't let fees get in the way of a successful business rescue. We'll never allow that to happen in the COBRA initiative. Yes, we do charge fees, but if the difference between a company being successful in business rescue or being liquidated is the fees, then those fees will be waived in their entirety or partially. So before I just wanted to say that before we move on with the fee discussion. The fees that are legislated in the Act are considered to be fairly outdated because the Act was drawn up in 2008 for one reason. We typically, on medium to large companies that can afford our fees, we charge a higher number than that. So we charge in the region of 2,500 to 3,000 Rand per hour. And we would, the business rescue practitioner is also entitled to charge a contingency fee at certain milestones of success or at the conclusion of the business rescue process upon a successful business rescue. It's very important that the business rescue practitioner charges fees based on real successes, real implementation successes that are achieved. And milestones can be things such as creditor repayments. We've structured business rescue plans in the past whereby once 30% of the creditors have been repaid, then we earn a contingency fee being X amount. Once 50% have been repaid, then we earn contingency fee Y amount. We've seen many instances in the past where other business rescue practitioners have structured business rescue plans whereby they get a contingency fee paid out to them on approval of the plan. Now, for us, that is a nonsensical contingency fee because it's not a milestone in the implementation of the business rescue plan. It is simply a case of earning a fee when the plan has been approved, and this unfortunately gives rise to a lot of to a conflict to an extent, because the business rescue practitioner may be encouraged to bend to the demands of creditors in order to get the plan approved so that he can earn his fee, and in many cases he would have bent to such an extent that the plan is no longer implementable. So one has to be very careful when, as a creditor and as a company choosing a business rescue practitioner, to be careful of things like that, like the way that he charges fees and so forth. Peter, anything else you want to add on that?
Yeah, I just want to mention that if as part of COBRA, in the event of the business rescue failing, there's a need in law to convert the business rescue into a liquidation. That normally costs, it's a high court application, and it costs between 30 to 50,000 rands. Part of the pro bono initiative is to, regardless of whether you pass the means test, if that happens, you will not have to foot the bill, so long as you jump into the COBRA ecosystem now, because you've got to give COBRA, Engage, Schindler's, IQ a chance to get the business up and running. And
sorry,
if not, the costs are covered.
I didn't finish your question. The question also related to disbursements. So business rescue fees and disbursements of the business rescue practitioner, in other words, the legal fees and other fees that he may incur, professional fees and so on, rank super preferent while a company is in business rescue. In other words, they get paid first. And then you also asked me about the skills, Maurice, that a business rescue practitioner requires. Now, CIPC requires a business rescue practitioner to be either an attorney or an accountant, not necessarily a chartered accountant, but, or somebody from a business management consulting profession. Now, that last one is obviously quite broad, but the actual skill set that is required to be a business rescue practitioner to do it properly is so much broader than being an accountant or an attorney or a business management consultant. We at Engaged and at COBRA, we have at our core all the senior individuals who, between them, we believe have all the skills to do business rescue and turnaround properly. A set of core business skills that comprise a joint sort of business acumen, if you like. Those skills being leadership skills, entrepreneurial skills, strategic skills, legal skills, finance skills, operational skills, deal structuring skills, and capital raising skills. Now, having those skills at our core really enables us to move quickly and be able to apply the necessary skills we deem necessary when we come across a company that's in distress. Furthermore, between our senior team members, and we've got an extensive, strong, very strong senior team within COBRA and within Engage, we obviously have substantial networks. Substantial networks of trusted individuals and trusted companies, trusted entities that span almost every industry that covers South Africa. Now, those specialist skills are critical when we come into a new business. They enable us to operate in almost any industry in South Africa, and we have operated across almost every industry in South Africa, where we apply our core turnaround skills, and then we bring in the specialist skills from our network. And it's very important for me to specify trusted specialist skills, because we need, when we have a specialist coming into an organization, he mustn't have other vested interests. His only vested interest must be in helping us to make the company work. So hence the word trusted that I use when I talk about the network of specialist skills that we have. So yes, it's almost impossible for a business rescue practitioner. It is impossible for somebody to have all the skills that I've listed, all the core business rescue skills. Therefore, the best business rescue and turnaround outfits in the country and throughout the world, for that matter, are comprised of a select group of core people at the heart of the business who have the core business rescue and turnaround skills and the networks to boot.
Yeah, I think it's important to mention that the partners and the board behind me does not reflect all the partners. There are far, far more partners that have come on board, and they're all committed to the pro bono initiative, and they've subscribed and agreed to assist with their skills and not charge in circumstances where the means test, as reflected on the COBRA website, is passed. Before we conclude with me asking Peter just to take us through his views on SAA and his experience with Foschini's, I just want to mention that business rescue does apply to closed corporations, but not to partnerships, sole proprietorships, or trusts. But COBRA is geared to handle a turnaround of these entities. So don't feel that COBRA is not for you if you fall outside of that. We still have the mediators, and we still would like the opportunity to at least try and negotiate with your creditors and see what we can do. Yeah, just to conclude, Peter, SAA Foschini's.
Mauricio, just so that we're clear, it's not Foschini's, it's Edcon.
Sorry.
As far as I'm concerned, Foschini is still healthy, even though they're all closed at the moment. Yeah, I always say that companies that are extremely difficult to rescue, in the true sense of rescue, i.e. make it profitable, get it stable again and hand it back to the owners. One of the most difficult ones is an airline business or any business where you're paying forward. So it runs down from the size of your airlines, which are huge, down to your local hospitality crowd that's taking deposits for events in the future. Travel agents selling tickets for payment now for delivery in the future. So anything where you're paying forward is a very difficult business to rescue. In an airline situation, very often the big airlines, and this is certainly the case with SAA, don't own their aircraft. They're normally on long-term leases, and that's the banks putting, or the institutions which fund aircraft funding, will retain ownership of the aircraft in some way, just to protect them for this very eventuality. So the practitioners in this case, the guys at SAA, don't have access to a huge number of assets. What they do have is access to some fairly profitable sections of SAA, such as the maintenance division, etc. So they can sell those off. But the whole rescue, as we've discussed earlier, is premised on finding this wonderful thing called post-rescue finance. In the SAA's case, the government's just advised that they've turned the tap off on any post-rescue finance. So the requested $6 billion that was required is not going to be forthcoming. So I'm afraid my view on SAA at the moment is it's headed for liquidation, or for a night to walk into the room and take it over, and there'll still be a compromise with creditors, but for another international airline to take it over. Edcon, interesting case. Edcon, during this period of shutdown, advised all their suppliers that they're going to be unable to pay their creditors only for the current month, but the past 2 months, so February, March, April, and they weren't too sure about May, whether they'd be able to settle their creditors. This is a massive blow for, there's a number of companies that are heavily exposed to Edcon, being the biggest retailer in the country, and a big blow for SAPOA, the Property Owners Association, and the landlords, because Edcon's in virtually every large shopping mall in the country. So for them to fail would be a huge blow to the economy broadly. But obviously we're in unusual times. So what Edcon is facing at the moment is, do they come out of lockdown in rescue, or do they go into liquidation, or do they find funding? The UAF provided their last tranche of funding. Edcon's got a fairly astute CEO, so he would have tried his damnedest to keep this thing going. And if anybody heard the announcement he made to suppliers, he actually broke down at the end of the announcement. It was very heart moving to hear a man of that stature who just couldn't cope with the fact that he had lost literally 1.2 billion rands worth of sales during the lockdown period. So the jury's out, but I suspect Edcon will go into business rescue.
We have a
bigger one to rescue, but obviously in a situation like that, one's looking at where the profitable stores are and where they're not. I think they've already had a number of compromises with landlords. So it would be a matter of how flexible everybody is to work with the practitioner to solve the problem.
Thanks, Peter. Peter, we have a question. Can a body corporate or a homeowners association go into business rescue? Thank you, Owen.
The body corporate as such is not covered by the Companies Act, so the answer there is no. If it's formed as a PTY limited or as closed corporation, I do sit on a body corporate where we do have a PTY limited that owns the property, it's part of the property on which the development took place. So the two working together, and in that case, the PTY limited could go into rescue, but no, the body corporate wouldn't if it's purely formed as a body corp, very similar to a trust.
Great. Thanks to the panelists. Thanks for the attendees. This has been a great show. Please, if you have any questions, if you want to set up a meeting, it's www.cobra.org.za, or you can email us at info see, there may be one more question. No. info@cobra.org.za. So thank you very much to everybody. Until tomorrow.
Thank you.
Cheers.
Great. Thanks, Maurice.
Thanks. Bye.